Ku Iluna, please rise. Ea ka aha ho o kolo kolo ki iki hana hano u a koa koa ho mai. This Honorable Supreme Court is now reconvened. Inoho Ilalu, please be seated.
All right, please call the case.
Case number SCWC-18-0000677. In Re FT by and through Aloha Nursing Rehab Center. Petitioner, appellant versus State of Hawaii Department of Human Services, respondent, appellee. And case number SCWC-18678. In Re FWH by and through Aloha Nursing Rehab Center. Petitioner, appellant versus State of Hawaii Department of Human Services, respondent, appellee. Arguing for petitioner, Aloha Nursing Rehab Center, Thomas Bush. Arguing for respondent, State of Hawaii Department of Human Services, Lily Young. Argument on the merits.
All right, good morning, aloha everyone. Our proceeding today is being broadcast live on our YouTube channel as well as on Olelo. Counselor, are you both ready to proceed?
Yes, Your Honor.
Ms. Young? Okay, so we have a total of 1 hour for oral argument, 30 minutes for each side. Mr. Bush, we will give you a warning after you've used 20 minutes. So we'll give you a warning so you can save that 10 minutes for rebuttal if you wish. And Ms. Young, we will give you a warning with 7 minutes to go in your argument. Thank you very much. Please proceed.
Thank you, Your Honors. Good morning, Justices. May it please the Court, Tom Bush on behalf of Petitioner, Appellant, Aloha Nursing Rehab Center for the benefit of FWH and FT in these consolidated cases. So first of all, I want to thank Your Honors for allowing this oral argument today. It's been a long road in this case, as you can see from the procedural history. But on behalf of my client, I really appreciate the opportunity to speak to you today. This case presents an issue to correct an injustice, a fundamental injustice, to remedy an injustice. And the injustice is the DHS practice of terminating Medicaid benefits for beneficiaries without notice and a hearing to anybody who can act responsibly on behalf of those Medicaid beneficiaries. There are two cases, they've been consolidated. There are factual differences between the two, but there is I'm going to try and speak to the common fact patterns in both of them, and will differentiate them as needed as I go through my argument. So the fact pattern is Aloha Nursing, as a intermediate skilled nursing facility, accepts a patient based on DHS's determination that that patient is eligible for Medicaid benefits. So Aloha Nursing relies on DHS determination that that person is eligible for Medicaid benefits to accept that person as a Medicaid patient. Now, Aloha Nursing is only allowed to look to Medicaid for payment. In other words, Aloha Nursing can't ask for a third-party guarantor, okay? And Medicaid eligibility, to be eligible for Medicaid, you have about $2,000 in assets, generally speaking, and a certain amount of income. This court has recognized in Bynum v. Magno, 108 Hawaii 8188, that the essential purpose of Medicaid is, quote, to provide medical assistance to the needy. So this is social legislation, which this court recognized in that case. So what happens? So what happens is the patient is accepted into Aloha Nursing, and then as things progress, the patient becomes incapacitated, and the responsible party for that person becomes incapacitated. Let me back up a little bit. So when a person is accepted into the program as a Medicaid patient, DHS regulations allow for somebody to be the responsible party. And that is under HAR 17-1711.1-12. So that responsible party is not personally on the hook for payment, but that person is somebody that DHS can contact to ensure that this person remains in compliance with Medicaid, because an application has to be resubmitted every year, for example. So what happens is the person is accepted. A responsible party signs up. Then the person signs an assignment of benefits, Medicaid benefits, to Aloha Nursing. So Aloha Nursing then receives payment from a DHS. However, as things progress, the patient becomes incapacitated, and that responsible party becomes incapacitated, either mentally incapacitated or even dying, passing away. For example, in FWH, the responsible party was the sister of the patient, and that sister passed away. So the patient was admitted in June of '04 and remained a Medicaid patient. In March of 2012, when there was a renewal when Aloha Nursing knew that there needed to be a renewal, Aloha Nursing learned that the responsible party had passed away, the sister had passed away, and also the patient was now deemed incapacitated. In FT, the other matter, FT was admitted as a patient by March of 2011, and thereafter, that person's responsible party, which was her husband, he was deemed incapacitated, and FT was also deemed incapacitated. So in those situations,
Do the regulations prohibit the nursing home from being designated as a responsible party?
yes, yes. Yeah,
There's a conflict of interest, right?
yes,
Yes.
yes. The nursing home cannot be the surrogate or the person who makes the medical decisions. The nursing home has to be is the medical provider. Okay?
Have you raised constitutional due process of your client's own property interests here?
So that
I
would
think
be,
I saw it on your opening brief on FT. but-
yeah, so that the constitutional argument that we're making is for third-party standing.
But you also raised the due process rights of your own
Yes,
client.
yeah, we do say that there is they have a right to payment. They have a right to Medicaid payment because under the way the regulations work, once a patient is admitted into the nursing home, in essence, that patient becomes the responsibility of the nursing home, and the nursing home cannot discharge that patient.
There are federal regulations that prohibit the discharge.
Prohibit the discharge unless you have another place that person can go to, that they're willing to accept it, that they have a plan of care, and you've confirmed all that, and that's realistically not going to happen with a Medicaid patient.
Have you been informed as to if this appeal right does not exist under the statute that was cited here, what other remedies Aloha Care, Aloha Nursing might have?
Aloha Nursing's own remedies is what
Right.
you're-
What remedies would Aloha Nursing have if not through this appeals process?
Aloha Nursing's own remedies would be, it would be circuitous, because they would have to sue the Medicaid patient. The Medicaid patient would then have to, they would have to claim some sort of, they would have the creditor of the estate if the person passed away. And then, it would be a difficult road to hoe because they don't have the claim directly against DHS.
Okay, so under the Medicaid regulations, you said that Aloha Nursing cannot collect directly from the patient once it's a Medicaid situation, right?
Well, if the person is deemed ineligible for Medicaid, then presumably they could collect,
I
right?
see, I see,
While they're Medicaid patient, obviously they can't
I
collect.
see. But then you, once they're deemed ineligible, you cannot kick them out unless
Exactly.
you have someplace else that will take
Exactly.
them.
Exactly.
So then you are basically required to continue to provide the care with no remedy.
Exactly.
Just because we're on this topic, if I could be clear on the record, in
Sure.
one of the cases, I think it was FT perhaps, that individual was determined to have assets. And was a lawsuit brought with regards to beneficiaries of that estate?
Yeah, so in FT, that was an interesting situation. So in FT, DHS made a determination that the person was eligible for Medicaid benefits. Then apparently they realized they'd made a mistake, or they perceived that they had made a mistake, because there was an asset, there was a home that was in a trust.
Right, a home, okay, yes.
And they were trying to, and so the problem was, and then Aloha Nursing was trying to work to assist in trying to find somebody to get the home out of the trust so it could be liened. So in other words, so DHS could continue to provide Medicaid benefits, but they would have a lien on the property. The problem was there were 3 sons, and who were perhaps beneficiaries of the trust. I'm not exactly sure, but they, 2 of the sons were willing to cooperate. 1 son was unwilling to cooperate, which held up the whole process. And as a result, it took, the house never left the trust, and FT died.
So, but to the extent of a remedy for Aloha,
Yes.
your client, is that asset a potential remedy? I'm just trying to understand the record here and the
So-
possible remedies, which is what I think Justice McKenna's question was.
Their agreement, they would have had to open up a probate proceeding, because it's a trust, right? The house is in a trust. So they would have had to open up a probate proceeding against their client, once their client passed, and then make a claim as a creditor against the client and hope that the property in the trust could be reached. And I don't know if that property could be reached under those circumstances.
But you're saying that in this case, in FT's case, there was apparently a house, but you're, I believe under FWH, the disqualifying thing was like $8,000 in a bank account, right?
Well,
And
actually,
so was there more?
the disqualifying event was the fact that FWH didn't submit a reapplication. So that was the disqualifying event. And then after that,
And then you are prohibited from, your client is prohibited from submitting the reapplication.
yes, that was the problem in FWH.
According to DHS, right?
Yes, yes, yes.
But it is, you said that it's a $2,000 asset thing,
Medi-
that in terms of assets that becomes disqualifying?
If you have more than 2,000 in assets, you're disqualifying from Medicaid, generally speaking.
So as a practical matter, if, for many of these patients, if they are found ineligible, your client is basically required to continue providing the care with very little, if any, possibility of any collection.
There's no realistic possibility of recovery in 99.99% of these matters. Yeah. So,
Counsel, if I may ask you.
Sure.
Does the assignment of benefits in any way qualify your client as a recipient of public assistance?
well,
Could that serve as a grounds to qualify them?
that's certainly not what any courts have held. I haven't seen that. That doesn't make them a recipient. They're in, yeah, a recipient is defined, well, under the statute. It depends on what you mean by recipient. So recipient under
As defined under the statute?
as defined under the statute is somebody who receives who is the beneficiary of, why don't I just look it up?
Yes, a person for whose use and benefit services are rendered or a grant of public assistance is made.
Right. So I think that's been held to be the actual, the beneficiary, the person receiving the benefits, and the benefits are not, it's not the money, but the benefit is the nursing facilities, the skilled nursing facility that's being received.
Even though public assistance is defined as financial?
Yes. Yeah.
Thank you.
Yeah. So,
Let me shift a little bit, Mr. Rose. You know, HRS 34612 restricts who may initiate a DHS hearing. And it's really a legislative policy declaration. You got the applicant, or we've been talking about the recipient. And then if you look at the rule, under the rule, an authorized representative can advocate. And it seems that you're suggesting that we import common law standing doctrines, and that would expand access to benefit hearings beyond what the legislature intended. I think that's what DHS is arguing. What's your response to that?
that's a great question. Because that to me gets to the heart of the problem of what makes this so upsetting. DHS takes away the patient's right to Medicaid benefits by violating the patient's due process rights to notice and hearing prior to the termination of benefits. So look at Goldberg v. Kelly. So under 42 CFR 431.205D, that regulation says the state's hearing system must provide for a hearing. It says before a Medicaid agency or an evidentiary hearing at the local level. 431.205 subsection D says the hearing system must meet the due process standards set forth in Goldberg v. Kelly, 395 U.S. 254-970. Now, what was Goldberg v. Kelly? Goldberg v. Kelly was a case in where New York had a welfare system where they would terminate you or reduce your benefits first, and then you could ask for a hearing later. That was their system. They modified it a little bit to say, okay, we'll give you written notice of what we're going to do, and you could submit a written response, and we'll review it before we cut off your benefits, but you're not entitled to a hearing until after. So you look at that case, because that case is right on point for what, in that case.
Could you give us the regulation citation again?
Sure. The citation is 42 CFR 431.205.
Thank you.
So that regulation requires the due process standard of Goldberg v. Kelly to be met. Well, what was the issue in Goldberg v. Kelly? I'm going to read it to you. And this is 397 U.S. 254. Looks like to me it's 260, page 260. The constitutional issue to be decided, therefore, is the narrow one of whether the due process clause requires that the recipient be afforded an evidentiary hearing before the termination of benefits, and before is italicized. What was the Supreme Court's opinion? The Supreme Court's opinion says, we agree, and this is again on page 264, we agree with the district court that when welfare is discontinued, only a pre-termination evidentiary hearing provides the recipient with procedural due process. And then the court later on explained, and this is page 267, 268, the fundamental requisite of due process of law is the opportunity to be heard. The hearing must be at a meaningful time and in a meaningful manner. In the present context, these principles require that a recipient have a timely and adequate notice detailing the reasons for a proposed termination and an effective opportunity to defend by confronting any adverse witnesses and by presenting his own arguments and evidence orally.
Mr. Bush, could you explain the sequence of the notice that was provided in the, at least in the FT case? What happened?
Well, there was no notice provided before benefits were terminated in both cases. So that's
That's because it was sent to the wrong place, or there was just simply no notice?
because there was nobody to, well, presumably because there was nobody to notify, because in those instances, the patient is incapacitated, in FT, the responsible party was also incapacitated. In FWH, the responsible party was dead. So in essence, but that didn't stop DHS from just terminating benefits.
But, I'm sorry, did they send a notice to these? What does the record show regarding what notice they actually sent and what happened with that notice? Did they just say, no can, or did they try and then came back and somehow established, like, hey, we tried our best, but we didn't know what to do, or how did they approach it?
And you're asking, I'll ask FT, talk about FT, since that's what you asked first. So all I know, because this is all I was allowed to know, was that after benefits were terminated, so benefits were terminated in November of 2012. On July 17, 2013, DHS sends notice of a benefit stoppage. I don't know to whom it was sent. I don't know that. There's apparently a screenshot of a computer that indicates benefits terminated, but we don't know where it went. We don't know to whom it was sent. For FWH, the only notice in the record that I'm aware of is so benefits in DHS were terminated as of April 1st, 2012, initially, and then they were reinstated later on. With respect to that stoppage in April 1st, 2012, I don't know that any notice, there's no record of any notice being provided to anybody. The only notice that is indicated being provided is DHS sent a notice on September 9th, 2014, that it was stopping benefits as of September 20th, 2013, because it didn't know where FWH was. FWH was in the nursing home. And,
You know, Mr., but, you know, their position is, hey, it's not a matter of notice, it's a standing issue. Getting back to my common law third party, you know, I'm just wondering, do common law doctrines, you're asserting third party standing here, how does that apply as an alternative to the statutory standing for DHS benefits?
so I'm sorry, and I got I didn't finish, I got distracted, but so the other case, so Goldberg is important because it shows that due process requires, you know, pre-termination notice in a hearing, okay? The other case to look at, and that I think addresses your question in part, is the Supreme Court, this court's case, which is Punahou versus Sun, or not Punahou, Punohu versus Sun, and that's 66 Hawaii 489. And in that case, so in that case, briefly, there was a, I'm over my 20 minutes, so.
You can keep going.
Okay, but in that case, there was, the plaintiffs were complaining that they didn't receive adequate notice of termination or reduction of their dependent care or their public assistance benefits. And this court eventually said the notice was fine, but in making that decision, this court did say, and this is at page 491 of the decision, the Supreme Court of the United States in Goldberg versus Kelly made it plain that termination or reduction of welfare benefits involved important rights of statutory entitlement which could not be accomplished consonant with due process without adequate notice and an evidentiary hearing prior to the termination or reduction taking effect. So it recognized that pre-termination due process is required. That's this Supreme Court. And then this court said the requirements of 45 CFR 2505.10, which is not important for our purposes, that has to do with welfare, taken together with the fair hearing provisions contained in 346.12, to get back to your issue, obviously satisfies due process. So my point, my understanding, the way I can reconcile this is 431.205, 42, 431.205, those due process requirements imported from Goldberg v. Kelly, plus HRS 346-12, that will comply with due process. Now, 346 so under that reading, you cannot, I don't think you can restrict applicant or recipient to the patient or the responsible party. I think you have to allow, in a situation where the patient is incapacitated, the responsible party is incapacitated, you have to allow for somebody acting responsibly on behalf of the patient.
So is this, under those unique circumstances, then you would suggest that third-party standing is applicable to an administrative hearing?
Yes.
Now, in a situation, I mean, DHS under 346.12 is dealing with all sorts of benefits. It's not just Medicaid benefits, right? I mean, so under your unique circumstances, it wouldn't apply for maybe, say, a landlord comes in and says, hey, I've got standing to argue my renter who lost his assistance allowance for rent benefits. That person would not be able to come in.
No, that person wouldn't be, because one of the requirements to have third-party standing is that you have to be allied with the person. You have to be on this. You have to have sort of the same interests in common, and that person has to be unable to assert their own rights for some reason. There's some hindrance. Obviously, if the person is incapacitated, the responsible party is dead, they can't assert their own rights. So, and the case that's analogous to this situation, I think, is Singleton v. Wolf, which is a U.S. Supreme Court case. In that case, a patient had, doctors were suing on behalf of their patients. Their patients were persons who were seeking abortions, but that state had a statute that said, unless it's medically necessary, we're not going to pay for it. We're not going to allow Medicaid to pay for it. Well, the doctors were allowed to have third-party standing to say, hey, look at, that's unconstitutional.
Okay, you know, is your position with the pre-termination notice and the arguments with Goldberg, I mean, is this becoming not really a third-party standing issue, or standings sort of off the table? I mean, I'm trying to understand what the true position is, because, you know, the ICA, the briefing, we're all talking about third-party standing, whether we have close relationships, the three-part test, all that. Are we just putting that aside, and this is just, you know, a DP termination?
There's two alternatives that I see. One is to say the statutory regime, to be constitutional, has to allow for a responsible party to act on behalf of a Medicaid patient where that patient is incapacitated and the responsible party is also incapacitated. You have to allow, to comply with Medicaid, to comply with Goldberg v. Kelly, you have to allow that. We have to read 346-12. We can't read it to prevent a responsible party from acting on behalf of the incapacitated patient. Okay, that's one. That's one argument for standing.
With okay, I'm sorry. Continue your point.
I'm sorry. And then the other argument for standing is more the straightforward argument that the Singleton v. Wolf, and that's the three-part test where you've been injured, you have a close connection with the persons whose constitutional rights you're trying to assert, and that person has some hindrance in asserting their rights themselves. So I think under either one you have standing, but they're alternatives.
So you are not claiming, you're claiming vicarious standing through the patients. You are not claiming standing on behalf of your clients themselves.
In that situation, yes, Your Honor.
In that situation.
Yes, Your Honor. In the third-party standing.
I understand, but
yes.
Are you claiming rights of your own clients themselves directly?
I haven't fleshed that out, to be honest, Your Honor. So I think it's in our reply brief to the,
I think in your opening brief to in FT, you claimed constitutional due process
We
of
did.
your own accord.
we did.
But I'm wondering if that's a claim you're pursuing.
That's a claim that I think we have under these circumstances, under the circumstances in which the medical provider, which my client is required to keep the patient basically forever without any guarantee of payment. So yes, Your Honor.
Anything to sort of wrap up for the court at this point?
Yeah.
And I will give you some extra time for
Appreciate
rebuttal, but anything more for us at this point before we hear from Ms. Young?
Unless you have, I'll wait and reserve my time, what little time I have for rebuttal. Thank you, Your Honor.
Very well, thank you, Mr. Bush. Ms. Young. You should probably pull the mic down, yeah. There you go.
Testing. Can you?
Should
Thank you.
Start, we'll let you know if we can.
Okay, thank you. May it please the court. Lily Young, Deputy Attorney General for the State of Hawaii Department of Human Services. The issue in this case is whether or not the provider, Aloha Nursing, had the authority to request contested case hearing in an entitlement action on behalf of two former patients who were deceased at the time the request was made. The answer to that is no. They had no statutory authority under 346-12 HRS, which reserves that right specifically to applicants and recipients of the entitlement. They are neither an applicant or a recipient. They are a provider of healthcare services. Second, they did not have actual authority. At the time this request was brought, their patients had already passed away. So they would have had to have gotten authority from the estate of the representatives to bring an action and act on behalf of these individuals. They were also unable to meet the third-party standing requirements, the criteria, the three-part test. The injury in fact, the close relationship, and also the hindrance. And we focus on the hindrance because in both of these cases, it's important to note that guardians were subsequently appointed. Aloha Nursing petitioned for guardians in both of these cases, so they were very much aware. Before the guardians were even appointed, before, in FWH's case, before effective date of termination in April of 2012, Aloha Nursing had already hired a consultant, sent them down to the Medicaid offices, realized that the reason for the termination was because they didn't submit renewal information.
Let me ask you this. I understand DHS's position is that Aloha Nursing cannot request a contested case hearing under 346-12 based on the statutory language. So what is their judicial remedy? They do have a right to judicial review in some form or another, so what is their judicial remedy?
So the individuals, right? Right. So
No, Aloha Nursing, what is their remedy? If it's not through the 346-12, what, because you're saying 346-12 doesn't apply.
right.
So then they could file a 632-1 DEC action?
So as a provider, you mean as a provider?
Yes.
Okay. As a provider, they have their own authority in which they could have requested a hearing. As a provider, they would only have the right to, in this facts of these circumstances here, request reimbursement, right? Basically, they're saying they want to get paid. They want Medicaid to cover the debt that was incurred while these people were being serviced, the patients were being serviced, and were not eligible for Medicaid.
Is that under a different regulation? Is that under a different
No,
statute?
oh yeah, that is. It's under HAR 17-1736. Subchapter 3.
They didn't request reimbursement?
They didn't request reimbursement at the time that they should have requested reimbursement.
But they did request reimbursement, right?
Well, they requested it at a time after the cases were closed.
All right.
So,
So then let's get back to the notice issue then.
Okay.
How was notice of ineligibility provided?
notice of ineligibility, a notice is sent out to the applicant or recipient or their authorized representative.
So in this case, FTs went to
FTs went to his home, FTs went to the
husband,
the husband.
the
FT's
incapacitated husband.
the incapacitated husband at the time, right? But the notice doesn't only serve that purpose just to be sent only to that person, because we don't know
Is it in
that.
the record, by the way? Is the notice in the record somewhere?
No,
I didn't see it.
Notice was not put in the record because that information, we weren't allowed to disclose that information without authority from the patient, the deceased individual's estates. So to release that information, we would have,
The home
Because-
address or the fact that this person was they knew that this person was the authorized representative, right? I'm a little confused. You couldn't disclose it because of some federal regulation?
right, because it's a confidential information. It's
What
Medicaid
was
information.
confidential about it? That it had been denied?
The notice,
The notice saying you're no longer eligible, that denial itself was, the
it's
determination was confidential?
it's considered information from the individual's Medicaid file, the Medicaid file.
I see.
Okay.
So then the provider who takes the patients in through DHS's determination of eligibility is not provided any notice of that determination being rescinded,
Not the provider,
not the provider.
not the provider.
So the
Aloha Nursing doesn't get notice that, you took this patient in based on DHS's determination that this person was eligible for Medicaid, right? And all of a sudden, the only way they find out that this person may have been found ineligible for some reason or another is when payments stop. Is that right? You never tell the provider, you never tell the Aloha Nursing that, hey, we found this person ineligible, so we're not going to pay you anymore.
Okay, I understand your question. So when a notice of termination or any adverse notice is sent out, it just goes to the applicant or the applicant's authorized representative. It won't ever go to a provider. The provider may find out some other way, like through the family or.
When the checks stop.
Or if they are mailed to the applicant and the applicant is a resident in their facility, then they'll open the mail.
Right,
Because
but
somebody else needs
if
to.
they open the mail, but otherwise, if it goes to like the husband's home,
Right,
the only way they find out is when the payments stop.
right. Well, they found, I don't know how, because that's not in the record either, but the record does indicate in their opening brief, they did say in FT's case that in November of 2012, that they found out that benefits stopped, and they found out the reason for the benefits stopping. And at that point, they started to address it. So,
But you're saying that, I understood DHS's position to be that not only did they not have standing to request a contested case hearing under 346-12, in any event, it was too late, because it was more than 90 days after the termination.
that was initially, I think that was in the initial dismissal before it went up to Judge Nishimura. And then when it was remanded down, I believe the issue was just narrowed to
To standing.
standing. And so that's why the timeliness argument wasn't
So basically,
addressed.
the federal regs don't, or the state regs don't have any process for a hearing for the actual provider?
Not to contest eligibility of termination, not to contest.
And do you agree with Mr. Bush's representation that the regs still prohibit them from kicking them out?
No, I don't, because
Okay.
at that point, they were considered private pays. So it's up to the nursing facility at that point to deal with the individual as a private pay. If they're not paying, what do you do?
Yeah, so
What
they
is your
should just
remedy?
kick them out, right?
Well, whatever their remedy is, to find a placement or to ask the family, because, if they will take the
If there's
individual
no
back.
placement and the family cannot or does not want to pay or not able to pay, their remedy is basically to push the people out the door.
Well, I'm looking at it from the Medicaid standpoint. The
Right.
program doesn't allow us to pay for people who are not eligible, do not meet that income criteria. So, our hands are tied as well. We cannot cover payment for someone who is ineligible for Medicaid because that goes against the entire program.
Doesn't your regulation 17-1725.1-60, that's the undue hardship. Explain how that would impact things. I mean, denial of coverage can be waived under that if an individual's life or health would be in danger. And I think that covers the situation where you're not wheeling a patient out into the street once DHS or Medicaid benefits rather are denied.
Right, so I think in those cases, if they can address the asset, then they wouldn't be able to, if they can dispose of the asset or do something to the asset so that they don't count it, then in those cases, the hardship would not apply because they can actively do something about it. I think the hardship would apply if there was some legal impediment that prohibited them from addressing whatever that barrier is or whatever put them over asset or ineligible for benefits.
Could you come back to your argument on third-party standing? Why isn't there third-party standing here?
Third-party standing, okay. So a three-part test. Injury in fact would have been fairly traceable back to what they're saying is their debt that they're owed is traceable back to the notices. But I don't think it was because of the notice. The notice was sent out because of the excess assets. That is what made those individuals ineligible for Medicaid. That is what triggered the notices being sent to terminate their eligibility. The second prong of that test is the close relationship. And Aloha Nursing asserts there's a provider-patient relationship. But all along, if you look at the facts in this case, they've always treated the individual, FT especially, as a debtor. They immediately, when they found out that the reason for the termination was the property in trust, they contacted the family, had the family members agree to be appointed co-trustees. After they passed away in 2015, they filed a petition to compel the trustee to release the assets to satisfy the debt. They're going after property. They are exercising their remedies. In the FWH case, after the guardian was appointed, they had all along been billing FWH for their services incurred, and they provided it to the guardian, and the guardian did attach it to their guardian's report to the court in the guardianship action. And it showed that the billing was addressed to FWH and what the debt was that was owing to them. So they were treating them like private pays, basically.
Didn't you also argue on the close relationship test that that the relevant relationship was between Aloha and FT's estate and not between Aloha and FT? That was your other argument on that, right?
Right. So because it occurred after, the request for hearing came in after both parties passed away, it would have been, and there was no evidence in the record to indicate that Aloha Nursing had actually contacted the estate or tried to get permission from the estate to act on behalf of these individuals.
But-
If, I'm sorry. go ahead.
But what I found strange about that argument is essentially you're suggesting that the third party standing depends on the person's life, FT's life. So say, you know, they were going, you had litigation when FT was alive, and then in the course of litigation, FT passes away. I mean, it just seems odd that that close relationship depends on the life of the patient.
Right. I think what they were trying to establish, well, when they made their argument, what I perceived it to be was that there was a provider-patient relationship. And because they brought the request after the individuals passed away, it seemed that they were trying to just collect money instead of really trying to do it for the benefit of the individual. Because if that were the case, then they would have brought this request at the time the individual was still alive and receiving services from them, and while the guardian was there and could have, you know, assisted in that matter.
What about the third prong of the third party standing test? There must be some hindrance to the third party's ability to protect their interests. Would you concede that, or what would you argue?
No, I would not concede that at all because in both cases, the guardians were appointed. Aloha Nursing petitioned for the guardians to be appointed, and subsequently they were appointed.
What about during the gap period before that appointment?
Right, so in FT's case, I believe November 2012 was the date that benefits were effectively stopped. And in January of 2013, the guardian was appointed. So it was a very short period of time. And at that point, after guardians were appointed, they both had access to the Medicaid file. They both could access the Medicaid file, which included the notices of termination. Notices that would have had the action taken, termination, the reason for the action taken, the excess asset, or the failure to submit their renewal information, and rights of appeal. Rights of appeal are if you disagree with the reason for the action taken, then, you know, request the hearing. So we believe that in both cases, as soon as the guardians were appointed, or even before the guardians were appointed, there was action taken by the provider Aloha Nursing that actually recognized the reason for the termination. And we believe that after the guardians were appointed, this information was shared with them because they were working with them. In one record, in FWH's case, there was a letter from Aloha Nursing to DHS informing them that they had been working with the guardian from February 2013. That's the month that the guardian was appointed, to address this California asset. So they were working together. So there was no reason for us to conclude otherwise that the guardian was aware and knew. The guardian had access to the Medicaid files. The guardian had access
Can
to
I
the
ask you though,
notices of termination.
independent of that, what if any notification is given to the facility that the patient is no longer eligible and payments are going to be terminated? And in that, are they given any type of reason or basis?
Notice is not given from the Medicaid agency. Notice may be given from the health plan because the health plan is the one that pays the nursing facility. So with respect to your former question, Justice McKenna, about asking the provider's right to appeal. For reimbursement cases, they knew from the time that both patients were admitted until the time that they were terminated in 2012, they knew the process for claim reimbursement because they were getting paid month after month, year after year, until 2012.
And what is the statute or regulation again for that reimbursement request?
The reimbursement request, statute or regulation, well, that would have come under their health plan and the nursing facilities contract. They have a contract because the individual, the patient at the time, they are assigned a health plan, excuse me, a health plan. And
Like HMSA or Kaiser
or United
Aloha
Healthcare
Care
or Aloha Care, right?
Aloha Care, one of
Right.
the
One of the
Medicaid
five,
ones.
one of the five Medicaid. So in order to get reimbursement, the process is that the provider submits a claim to the health plan for services rendered. And then if the individual is Medicaid eligible, the health plan will pay.
Right.
We don't have a direct contract.
But the health plan but DHS makes the eligibility determinations, right? It's not the health plan that makes the eligibility determinations.
Correct. So it would be the health plan, though, that sends the notice to,
And
the
in terms
provider.
of undue hardship, that regulation, your DHS position is that it would have to be the authorized representative or the recipient to assert those rights.
for the well, to assert those rights. Yes, to act on behalf of the individual to assert those rights.
And if, like, in a situation like this where let's say a situation in which the patient has passed away, there's really no estate, what interest does the guardian have in trying to pursue payment so that the nursing home can get reimbursed? I mean, they're representing the interests of the deceased or the incapacitated person. If they don't have assets and they're still being treated, what interest does the guardian have?
I can't. Does the guardian?
I'm really getting down to, like, what rights do the nursing homes have under these situations? They have no rights whatsoever. You're saying they can't sue, they can't get a contested case hearing under 346-12. So then do you concede that they would then be able to file a DEC action or something requesting payment?
I would say they don't have rights to sue on behalf of the individual unless they have the individual's consent. But again, they do have rights to request a hearing for claim denial. So at the time that,
Where is that? What statute is that?
again, HAR 17-1736, that's that chapter that
Okay.
allows them to, allows them a hearing if they,
Isn't that what they requested, a hearing?
but
It
not,
wasn't under 1736?
no.
They filed it under,
No, they didn't file it. They didn't file it as a provider. What they were trying to do was come in as the individual.
I see.
They
So you're
didn't-
saying that they could have filed it as a provider,
Right, but they would have had to follow that procedure,
1736 procedure.
right?
Is there a time limit in terms of requesting a
Right.
hearing?
So for claims reimbursement, there is a time limit. I understand, but there's a process with the health plans that they would have had to have filed the request. And I think, I want to say, and I'm not sure about this, but I believe they have a year after the date of service, from the time of service. They have a year to file their claim with the health plan.
Through that process, can they challenge the eligibility of the patient?
No, but they they could probably raise it, and if they had evidence that the individual was eligible, then they could present it in their case at that time. But more importantly, for claim denials, the health plan would have issued them a written denial in which they could appeal that and then eventually make their way to DHS's forum to say, we should have been paid this because they should have been Medicaid eligible.
Wait,
So-
no, wait, how is that? Is that under it's not under 34612, it's under HAR, but isn't that just involving applications? I mean, and then the authorized rep or two, somebody acting responsibly do that? That to back up, that hearing that you're talking about, what is that hearing?
The provider hearing or the one that they requested?
Let's call it, well, both.
Okay, so for the hearing that they requested, the information that was provided by them and the actual application for hearing that they made was to contest on behalf of the individual because it read, my benefits were denied, my renewal determination was denied. So we took it to mean that they were trying to act on behalf of the applicant recipient. In a provider's claim for reimbursement, they would have been able to attach their own denial addressed to Aloha Nursing, saying, "Dear Aloha Nursing, your claim for reimbursement is denied for X reason," and they would have been able to appeal that.
Under HAR 17-1703.1-3, this is the provision that speaks to a right to a hearing. Part of the notice that's supposed to go to a beneficiary or, I guess, a recipient, using the language under the rules, is that they're supposed to be notified that in challenging a denial, that they could have an authorized representative, right? And part of it is perhaps they could designate. Would they be able to designate the nursing home?
Sometimes they do, but a lot of times they don't. It just depends on the circumstances. I think it just depends on whether or not they were able to get consent.
Well, they can. The point is they can, right? They can. Whether they
Yes.
do or
Well,
not, they
I
can.
thought Mr. Bush was saying they cannot be the authorized rep because there might be a conflict.
Right. So in that case, I think that they would need to examine whether or not they would be able to represent that individual if they were asked by the individual to be appointed as their authorized representative. Because there is a conflict, right, in terms of representing them in a hearing versus making healthcare decisions for them and then saying, yes, I'm approving the healthcare decision and I'm going to be paid for that, right? So two different situations. I'm not sure that covers it all, but that's why it depends on the situation. But in these two cases, I mean, let's not forget the fact that guardians were appointed in both cases and that they were able to act and reapplied for both individuals. One was denied, and at that point, they were able to request a hearing probably they could have raised it back to 2012 because the reason for their denial was the same reason that they were denied in 2012. It was because of the excess asset. That went nowhere. That has remained intact all along. In FWH's case, the guardian was able to get rid of the bank asset and reapplied successfully. So this person went back on Medicaid, right?
But real quick, on timing, you're saying, hey, there's a guardian. Guardian was appointed in both cases. Was it within the 90 days that they would have been able to challenge the specific denials here?
They weren't, I think.
That's part of the challenge is like it takes a little while to get those
In
guardians.
FT's case, they were denied they were appointed within the 90 days. In FWH's case, not, but after they were appointed, after they reapplied and successfully were approved, they have that opportunity to request a hearing as well. All approvals, all denials, all notices that get sent out, they are allowed to request a hearing, and they could have at that time said, this 3-month retroactive effective date, I disagree with that. I think it should have gone back to 2012. They could have raised it at that time.
What's the specific authority for them being able to ask for that type of a hearing after the 90 days?
So the notice, I would say that the notice, notice of approval includes rights to appeal. That's HAR 17-1713.1-4 subsection A, subparagraph 5.
Now, you also indicated that they could seek review under 1736 as provider's right to review, is that right?
Providers' right to review, they're allowed to request a hearing if they are denied their claim for reimbursement.
Where is that? Because I'm looking at 1770-36-33.
Subchapter 3, I think it is.
Could you give us a cite again?
Could you give
please?
us a citation right? Because I'm looking at 1776-33, and it says a provider may request an admin hearing following department's administrative decision to do 4 things, but it doesn't say anything about reimbursement. It's about withholding the provider's certification, withholding payment of claims as a result of an audit or investigations, recover money claimed to have been overpaid, impose remedies established that do not meet the nursing home requirements. So what rule are you saying would allow them to seek a admin review for denial of reimbursement?
I think it's under that. I think it's the second one. Is it the second one?
Withhold payment of claims as a result of audit or investigation? Is that what it is?
No, sorry. Sorry, I don't have that site right now. But they do have that right. And their right lies in that procedure with the health plan, because the health plan is the one that issues their notice of denial to the provider and allows the provider the right to appeal. And within that right, they have the right to appeal within so much time.
Very well. Anything you wanted to bring to the court's attention to wrap up today? I'll let you go a little further if there are things you need to cover, but.
Right, so the hearings officer, the circuit court, and the ICA all found in favor of the Department of Human Services because they found that the provider didn't have statutory authority, did not have actual authority to request a contested case hearing on behalf of their former patients. And in these cases, guardians were appointed to protect the rights of the individuals, and they had a lot of opportunity to do so. What we also want to make a point of is that the provider as well as the guardians recognize that the reason for the termination was valid because they worked so hard to remove that barrier before they could reapply them for Medicaid, and in one case, successfully did so. So, going back, if they do have the right to bring the hearing, what would they contest? They would contest the reason for termination, but they worked so hard to remove that reason, that barrier to eligibility. So what would the results have been? The results would have been the same. Additionally, the hearings officer, we believe, did not commit reversible error in exercising his discretion to exclude or not allow cross-examination regarding the notices, because that, in his discretion, I think he felt it had nothing to do with the issue of standing. Therefore, based on the arguments before you, the records in this case, that we'd ask this court to affirm the decision of the ICA.
I have a follow-up question. I'm so
Yes,
sorry.
Your Honor.
So I found 17-1736-58, which deals with hospital and institutional providers' right to review. And it says a provider may request an admin hearing if it is dissatisfied with the department's determination of Medicaid reimbursement. 1, following any request for rate reconsideration, following the issuance of an NPR under cost reimbursement. I don't know what NPR is. The amount in dispute is at least $1,000. But the next section, 17-7036-59, entitled Limitation of the Right to Review for Hospital and Institutional Providers, it says a provider shall not have the right to an administrative hearing as provided under the subchapter if the provisions of section 1736-58, which I just read, are not met, or the administrative hearing concerns the following: a determination of non-payment for items or services provided to recipient, but which are not covered by the Medicaid program.
Right, so at the time that they would have requested that hearing in 2016, as I said before, the case was closed. They are no longer Medicaid individuals.
Wait, but this seems to say that if the reimbursement request, you don't get a hearing if the reimbursement request is based on services provided recipient that are not covered by the Medicaid program. So you already determined, DHS already determined that these people are not covered by the Medicaid program,
Correct.
right?
Correct.
So do they get a hearing under this then?
We don't think that they would have gotten a hearing because of the guardian's decision. The guardian's decision to act on behalf and protect the rights of the individual. So allowing them to have a hearing then, I mean,
Well, but see, obviously you can see that my concern is that our law is pretty clear that there is a right to judicial review somehow. So I'm trying to figure out how they get judicial review. And you're saying it didn't come under them asserting the rights of the claimants. So then you said that they can claim the rights for reimbursement themselves. But now when I read the rule, it doesn't seem like they can. This rule would allow them. So I just want to, I'm trying to figure out how they get someone, either the direct, you know, because it has to go through the admin director for it to come to the courts for review. We've made that pretty clear that, you know, Alakai Keiki versus Matayoshi, there's a right to judicial review. It's got to be some way to do it. So I'm asking DHS to tell me, how do they pursue their rights that get to court?
the only thing that I can think of is that, you know, because the guardians were appointed to go through that route, if they disagreed with the way that the guardians acted, the inaction.
They sue the guardians under what, 632?
Well, to go back into, they could have at the time, the guardians were still appointed. You know, if they disagreed with their action, to go back into the probate court.
But we get back to this, like, what if there's no assets? So I'm not talking, I'm looking beyond the
Right.
facts of these two cases.
It's at
Most of these people have no money. There's no estate. There's nothing they can collect on, right? So what, you know, pursuing the guardian or pushing the guardian, if the people have died and they've already received the services, I don't understand why the guardian would be coming after. And it's actually the providers that are out, right? So I'm trying to figure out what rights they might have to try to seek some sort of reimbursement.
Well, I think if they worked the process at the time that the individuals were still alive, they might have gotten a shorter period of time. I'm not sure. I mean, I can't say for sure. It was just timing on all of the requests that were made. But it looks like in both cases, you know, there were assets owned by the individuals. Although that asset may have seemed small in FWH's case, it still made them ineligible. And according to the Medicaid program rules, if you don't meet the criteria,
I
you're not
understand.
eligible. You
But
understand?
let's assume it was just $8,000, right?
Just, I'm sorry.
If somebody had more than $2,000, right, they're ineligible, right? As a practical matter, it doesn't even cover 1 month, right?
Correct.
Thank you.
Very well. Anything further at this time, Ms. Young?
No, thank you.
All right. Thank you very much for your argument. Mr. Bush, your rebuttal. I will give you some extra time.
I appreciate that, and I'll try and be brief. I appreciate the extra time. Initially, I want to point out that that the Aloha Nursing, once it accepts the Medicaid patient, it can't discharge the patient. It really cannot. And you can look at 45 CFR 483.15, subparagraph C.
One more time, please. 45 CFR.
45 CFR 483.15, and then look at subparagraph C. And there's a whole host of conditions that must be met before a patient is transferred or discharged. And in the interim, the provider is prohibited from discharging or transferring the patient. And those provisions include ensuring that there's a safe place to go to, ensuring that that person's going to accept the patient, ensuring that there's a plan of care that that patient's going to receive. So who's going to accept a Medicaid person deemed ineligible by Medicaid who has no assets? It's not going to happen. And so then the other thing that that was never addressed or never answered or never really talked about by the state is the due process issue in the first place. That is, they terminated these folks. They knew, in both instances, the state knew that the person was incapacitated, the patient was incapacitated, and that the responsible person was either dead in FWH's cases or also incapacitated in FT's case. And yet they're sending notice to those two persons. They know, and Aloha Nursing knows that it's, yeah, you're right. Aloha Nursing knows it's not going to get paid because it doesn't receive money. Yeah, so they know something's up. In FWH's case, they tried to submit an application. They tried to start the application process, and they were rebuffed. And in the FT case, yes, they went to try and get a guardian appointed, but they don't have control over the guardian. They don't have control of the guardians that are appointed. Did DHS provide notice to those guardians? Tell those guardians that, you know, you can contest this? Now, for FWH, Aloha Nursing submitted an application to appoint a guardian. And that guardian, they found somebody who was a cousin or some removed cousin of the patient. So who's going to want to be a guardian if you're told, you know, what you need to do once you be a guardian is you need to go file an administrative claim against DHS because they stopped benefits? No, what the guardians do is they reapply for benefits. And if they're successful, DHS will allow a 3-month look-back period. That's it. But the guardian has no incentive to go further back and to make up all the money that was that would be owed to Aloha Nursing for all the care that was provided that was not compensated. The guardian has no incentive to do that. And the guardian isn't notified, and there's no indication that the guardian was ever notified that, hey, this was terminated on this date for these reasons. So what DHS is doing, what they're really doing is they're really foisting their responsibility to provide pre-termination notice and a hearing. They're foisting that on Aloha Nursing, and they're foisting that on these guardians. And that's not right. That's not what they're allowed to do.
So from a practical standpoint, what you are seeking would be notice to you, your client, before benefits are terminated, and to allow your client to participate, to pursue a hearing challenging the denial?
My client as a responsible party, so
Right.
there's the regulation that allows a responsible party to act on behalf of the incapacitated person. There is that regulation, and I think, so my solution, suggested solution, allow that responsible party to work with DHS to address the issue so somebody gets appointed to whom notice and a hearing can be given.
How is DHS notified who that responsible party is?
Well, in FWA, in FWH's cases, Aloha Nursing contacted DHS. I mean, they went and they gave them the information. So, I mean, Aloha Nursing has an incentive to do this because obviously.
Stay close to the mic.
I'm sorry. Aloha Nursing has an incentive to do this because they're being, otherwise they're not getting payment. And the
Right.
person they're providing services for the
So
patient.
I think that kind of goes to my question under the rule that I cited, which it says that a recipient can designate an authorized representative. Can that be done like beforehand, before you get to the point of a denial? I mean, because the patients that your clients deal with are oftentimes things happen.
Sure.
On a dime, and health situations can change. So is there a situation that you're aware of, counsel, that ahead of time, a patient can designate Aloha Care as an authorized representative?
I'm not aware of that, and I'm not sure that Aloha Nursing could be an authorized representative, because then you would have, I mean, they would be the ones, are they making medical decisions for the patient? They're not allowed under the rules to be the surrogate for the patient under the HAR rules. They're not allowed.
What about this? You come in an admission, you have them assign, the benefits. And in fact, at least with FT, I saw an assignment of benefits once they come on an admission. And then, you have an authorized rep there. In case of FTs, it was the husband. What about a situation, couldn't Aloha or some provider say, all right, if the authorized rep is somehow incapacitated, passes away like the sister in FDWH, Aloha is the authorized rep only for purposes of an eligibility? Is that a possibility?
It may be, I don't know, to be honest, I don't know.
Are there some federal regs on this about conflicts of interest?
There are federal regulations. That's why I say I don't know. I don't know if that skirts it, if that satisfies that or not. I don't know that.
And one of the reasons too is because you're arguing this responsible person to be able to challenge the denial. But what is the difference? I mean, wouldn't there be a conflict there as well? I'm not quite understanding the difference in those two situations.
So in the situation where the patient is incapacitated and there is a responsible, where the patient is incapacitated, somebody has to act on behalf of that patient. And it's not, I don't think it's allowed, I don't think it's constitutional to allow DHS to terminate benefits prior to providing somebody who can act responsibly on behalf of the patient with notice. And what I'm suggesting is that DHS be allowed to take information from somebody acting responsibly on behalf of the patient, in this case, Aloha Nursing. And they are allowed to disclose confidential information if it's necessary for to carry out their responsibilities. And that is HRS 346-10 subsection A2 says that the use and disclosure of information concerning applicants and recipients shall be limited to, and number 2 says, A2 says, purposes directly connected with any investigation, prosecution, or criminal or civil proceeding conducted in connection with the administration of any form of public assistance. So they're allowed to disclose information if it's in connection with any investigation concerning the administration of any form of public assistance. And then subsection 3 says, disclosure to the extent necessary to provide services for applicants and recipients, to determine eligibility, or to determine the amount of public assistance, including verification of information provided by the recipient of public assistance, medical assistance, or food stamps, or to determine the type, kind, frequency, and amount of social services, including health and mental health services needed. So DHS can work with Aloha Nursing. They can say, hey, look it, we know that the patient is incapacitated. We know the responsible person, we've not been able to find them. They've passed away or they're themselves incapacitated. Here's our issue. Our issue is this. You are the medical provider for this person. So, we need to resolve this. Get a guardian appointed and have that guardian so that we can provide notice and an opportunity for a hearing for that guardian and find somebody. And if they can't find somebody, then it's going to be OPG, Office of Public Guardian. And, but somebody has to act responsibly, be able to act responsibly on behalf of the patient before you terminate benefits. You don't terminate benefits and then 6 months later, a guardian is appointed and say, well, the guardian could have done something. I mean, that's what their position is.
I think the challenge is trying to figure out where circumstances can vary so dramatically, case to case, how you set a principled course. That's the question.
And that's, yeah, and it is a great question, and that is a tough issue. But, under the regulations as they currently are.
Mr. Bush, I will ask you to begin wrapping up.
Okay, I'm going to wrap it up now. I will say that under the regulations now, DHS is obligated to provide notice and then maintain benefits after it has provided notice where the patient asks for a hearing until a decision is rendered. That's under the regs currently, and that's HAR 17-1703.1-5. So that sort of contemplates the situation where you've given somebody notice, and if they ask for a hearing, then you can't just, terminate their benefits. You have to have a hearing where cross-examination is allowed, witnesses are allowed to be called, and then a determination is made. So, Your Honors, in this case, we have the situation where DHS is allowed to terminate Medicaid benefits for patients who really don't have other assets, and in the interim, Aloha Nursing, as the provider, is required to continue to provide services for those patients, but Aloha Nursing is not allowed by DHS to intervene in any way, shape, or fashion to ensure that those benefits, in fact, are not improperly terminated. And that's an injustice, and that needs to be corrected. And so we're asking Your Honors to correct that and allow, in connection with granting my client either standing under the statute and the regs under the two Hawaii Supreme Court's case and Goldberg case, or under third-party standing. Thank you.
Very well. Thank you to both our counsel for your arguments today. The court will take this matter under advisement.
Eku Iluna, please rise. Ua ho'o malolo ia mai ne kea aha ho'o kolo ki ike hana hana. This Honorable Supreme Court is now recessed.